All right, so we're recording. Good afternoon. This is cause number 2020 CI 0000X, styled Adam Smith versus Megastore Incorporated. This is a mock hearing. Today's date is March 27th, 2020. Due to the COVID-19 pandemic, the Texas Supreme Court has issued an order allowing courts to hold hearings remotely. This hearing is being conducted on Zoom. To comply with the constitutional requirements for open courts, this proceeding will be recorded by the court for training purposes only. We are on the record with the 45th official court reporter, Ms. Maria Gallegos, who is participating remotely by Zoom. All other recordings of these proceedings by audio or video is prohibited by law. I'm going to ask the attorneys to please state their name, the party they represent, announce your witnesses, announce whether or not you agree to proceeding in this manner that we have stated via Zoom, and if not, be prepared to state your objection. So with that, may I have the attorneys representing Mr. Adam Smith make announcements for the record.
Javier Espinosa and Laura Brock for Mr. Adam Smith, and we have Adam Smith here via Zoom as well, Your Honor, and we have no objection to proceeding under the Zoom, this proceeding in this manner.
Thank you, sir. On behalf of Megastore Incorporated.
Good afternoon, Your Honor. This is Lamont Jefferson here with Emma Cano. We represent Megastore. We have our corporate representative ready to testify, and we have no objection to proceeding in this manner.
All right. Thank you, sir. And now, am I to understand the witnesses for these proceedings are parties? Is that correct?
Correct, Judge, and they're both, I believe, online, waiting to be sworn in.
Okay. Then let me have the witnesses please raise your right hands. I see Mr. Smith. Where is the corporate representative? There you are. All right. Will you please raise your right hands? Do each of you swear or affirm that the testimony you're about to present to the court and for the record will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Smith?
I do.
All right. Thank you. And something that came up with Judge Alvarado before is that because these are party witnesses, they will remain present throughout the course of this hearing. All right, with that, Mr. Espinosa, who will be doing the opening statement on behalf of Mr. Smith?
Your Honor, I will be, Ms. Brock will be doing the opening statement, but before we get to the opening statement, we have some preliminary matters to take up. Number one, we'd like to move for, to pre-admit plaintiff's exhibits, and I believe the defendant has some exhibits that they would like to pre-admit as well. For the record, we have submitted plaintiffs 1 through 9, and we have shared those with the court reporter previously. My understanding is that we have an agreement as to 1 through 7, and defendants have an objection to exhibits number 8 and 9, and so those will be be taken up with Your Honor.
Okay, yes, thank you, and I apologize. I should have asked for pre-trial matters. Who will be handling the argument regarding plaintiff's exhibits 8 and 9?
That'll be me, Your Honor. Yes,
ma'am, you may proceed.
Your Honor, with respect to plaintiff's exhibits 8 and 9, those involve an OSHA citations that were issued to Megastore, I'm sorry, I forget the name, to Megastore, and the resulting settlement agreement that was reached by the parties in that matter. And so that was an agreement that was negotiated between the parties in that separate proceeding. It has nothing to do with this lawsuit. It was a completely unrelated incident. When the parties negotiated as part of the incentive for the parties to actually enter, or for the defendant in this case to enter into that settlement agreement, there is a provision that basically says that the agreement is going to be utilized solely for purposes of that OSHA proceeding. And so with that, I would like to show to the court Exhibit 9 so that we can reference, and I'm not going to show the full document, I'm just going to point to the relevant provision. Okay. So paragraph 10, can y'all see the document?
Yes,
Yes.
ma'am.
Okay, all right, perfect. So paragraph 10 says, none of the foregoing agreements, statements, stipulations, and actions taken by respondent shall be deemed an admission by respondent of the allegations contained within the citations, notifications of failure to abate alleged violations, and notifications of penalty herein. The agreements, statements, stipulations, findings, and actions taken herein are made solely for the purpose of settling this matter amicably to avoid protracted and expensive litigation, and they shall not be used for any purpose or in any proceeding except for proceedings and matters arising under the Occupational Safety and Health Code. Your Honors, so this agreement, when the parties entered into it, specifically contemplated use in another proceeding such as this one. And so when Megastore agreed to the settlement, they were counting on these citations not being used against them. And so for those reasons, we would ask that both the settlement and the initial citations be excluded from evidence in the record in this case.
Mr. Espinosa, your response, or will Ms. Brock be handling this argument?
I will be handling the argument, Judge.
Yes,
Thank you, Judge. Just briefly, Judge, to give you a very, very brief background, the allegations in this case are that Mr. Smith was burned with chemical from a dispensing unit at the Megastore where he had to mix water with chemical. We allege that he had chemical burn, some of the chemical spilling onto his leg. One of the defenses in this case from Megastore is that they were unaware that this chemical could cause the type of injuries that it caused Mr. Smith. And so for that reason, we're not offering these exhibits for admission of guilt or for any type of admission other than for notice and for knowledge on the part of Megastore. I want to show the court our exhibit number 8. Let me come in here real quick, see if I can do this. Oh, there it is. Can everybody see that? Can you see
not
that?
yet. Yes,
Yes.
now we can.
Okay. So here is a citation, Judge, that was a repeat citation issued in 2012. And it says that back on August 17th of 2011, the employer, and let me see if I can, okay. If we look here, Judge, the maintenance department, on or about August 17th, 2011, the employer did not provide training to employees in order to know what PPE, and for the record, PPE stands for personal protective equipment, was necessary, what personal protective equipment was necessary, and the limitations of the PPE. Employees work daily with crew restroom floor and surface cleaner, a corrosive material, and do not wear any eye or face protection. This was the second time they had been cited, Judge. And if we keep going on our Exhibit 8, they had a second citation where it says that the employer did not ensure that maintenance employees were required to wear safety goggles or a face shield, etc. Again, when working with this cleaning material. And lastly, Judge, and this is where we believe is the most important, it says on or about August 17th of 11, employees who work daily with materials such as, but not limited to, Prominence Heavy Duty Floor Cleaner. That is exactly the chemical, Judge, that we're alleging that Mr. Smith was burned with in our present case with Prominence Heavy Duty, and the court will hear a lot of evidence about Prominence Heavy Duty Floor Cleaner. When their defense is that they cannot, they were unaware that type of injury. Can somebody please tell Benjamin to mute audio, please? Ben, will you mute your audio, please?
Yes.
Thank you. And when we look at this, Judge, employee training right here shall include at least.
Mr. Espinosa?
Yes.
I'm sorry, hold on. For purposes of the record, if everybody, with the exception of Mr. Espinosa and Ms. Scano, please mute your audio. Okay, thank you, sir. You may proceed.
Thank you, Judge. In this same citation, this is what Megastore was required to do. Employee training shall include at least the measures employees can take to protect themselves, such as specific procedures, appropriate work practices, emergency procedures, and personal protective equipment to be used. Our main allegation in this case is that they didn't provide the correct personal protective equipment for Mr. Smith to protect from getting burned from this prominence heavy duty. So we believe that these OSHA citations go directly to knowledge where OSHA had notified Megastore a few years back that their employees could get injured with this chemical. The second one that is under objection is the stipulated settlement. After these citations, Megastore entered into these stipulated settlements where they agreed to pay $155,000, from $239,000 to $155,000. And I want to refer the court to exhibit number 9 on page 11, where it goes through what agreements Megastore entered into with OSHA.
And Mr. Espinosa,
Yes, Judge.
on exhibit 9, where is the relevant, I guess, stipulation regarding notice?
Here it is, Judge, and I'm referring to page 11 of Exhibit 9 under C. It says, in addition to otherwise complying with the hazard communication standard, respondent will revise its procedures, training, and hazard communication programs for all chemicals, including for any cleaning chemicals used in respondent solution center dispensing stations. That's exactly the dispensing station that Mr. Smith was burned on here in our case, in covered work sites. And if you look at number 2, employees and managers will engage in proper use and maintenance of Respondent Solution Center cleaning chemical dispensing stations in order to avoid handling any undiluted cleaning chemicals. Our allegation in this case is that Mr. Smith was burned with, when he came in contact with the undiluted cleaning chemical named Prominence. So Judge, with this stipulation, the citations, they're put on notice that this chemical can burn people. They agree and they stipulate to a stipulated settlement saying, we agree that we're going to train our employees, we're going to provide the proper personal protective equipment for them so that they don't get burned. And other stipulations that, for brevity's sake, I won't go through every single stipulation, Judge, but we believe that this does not go to any admission of liability in this case, but merely goes to notice on the part of Megastore that they had been notified this chemical can burn your employees, and you have to have proper training and proper personal protective equipment for your employees. 2 of the items that we allege in our case, they did not provide for Mr. Smith. And for those reasons, we believe that they are highly relevant, Judge. And we would move to admit them.
All right, thank you, Mr. Espinosa. Ms. Cano, your rebuttal?
Your Honor, I object to Mr. Espinosa basically testifying and trying to prove his case through his own testimony. But the fact of the matter is, this was an agreement that was reached between the 2 parties with the understanding that those citations and that settlement agreement was not going to be utilized against the defendant, Megastore, in any other proceeding. For those reasons, we would ask that both of these exhibits be excluded from the evidence.
All right. Plaintiff's Exhibit 8 will be admitted over objection. Plaintiff's Exhibit 9 the objection is sustained and it is offered but not admitted.
Thank you, Judge.
Your Honor, I do have an order that I just uploaded into the chat room. If you can access that.
I can, and I can open, I'm downloading it now.
As long as you have our order, Your Honor, that's just our proposed order, so you can do what you want with it.
Okay, so what we're gonna do is I will have it filled out consistent with the court's rulings on the record, and it will be circulated to attorneys of record after the hearing.
Okay, thank you, Your Honor. And one additional matter, so I have now uploaded into the chat room, oops, I did the wrong one. I meant to upload defendant's trial exhibit list. And so we're putting that in the chat room for Ms. Gallegos so that she can have as she prepares the record. And we have already exchanged and provided defendant's exhibits 1 through 4 to all counsel and to the court. We would ask that defendant's exhibits 1 through 4 be admitted. They have been agreed to by plaintiff's counsel, and we ask that those be admitted as evidence in the record.
No objection, Judge.
All right, then for the record, defendant's exhibits 1 through 4 are admitted.
Thank you, Judge, and I believe that's all the pretrial matters we have today.
Okay.
That's
Mr.
correct, Judge.
Espinosa,
Ms.
that's
Brock will
correct.
be doing the opening. Sorry.
Okay, no worries, thank you. Ms. Brock, you may proceed with your opening. Ms. Brock, I think you're on mute.
Thank you, Judge. Give me just 1 second. I briefly had to make an amendment to my opening presentation based on your ruling. Okay, Judge, thank you. I'm ready to proceed. May it please the court?
Yes, ma'am.
Judge, I've prepared a brief PowerPoint presentation for my opening argument that's been exchanged to my opposing counsel. So if I may publish it.
Yes.
Judge, this matter is a case Adam Smith versus Megastore Inc. Megastore Inc., as part of its maintenance routine, has its employees utilize a solution center that's found in the back of its store. And amongst those chemicals, we have undiluted, concentrated chemicals that are found at the top of the solution center. And one of those chemicals is called Prominence Heavy Duty Floor Cleaner. In order to operate the solution center, employees turn the knob, they then press the button, and the diluted chemical is mixed behind that chemical machine with water in order to come out to the right dilution level. The problem is that these chemicals, especially in their undiluted form, have specific known hazards. They are marked and regulated by OSHA. They're known to be skin corrosives and irritants, and they can cause chemical burns. In 2012 to 2013, OSHA cited Megastore specifically for hazards created by these chemicals and specifically named Prominence Heavy Duty Floor Cleaner in these citations, identifying hazards that were presented to employees. Employee training then needed to be included and supplemented using training on the specific hazards of those chemicals, what PPE is necessary, to make sure that these employees know what the dangers are of working with the chemicals. When my client, Adam Smith, went to work for Megastore, he was finding a second job. He's a prior Air Force veteran. He worked as a social worker during the day, but in order to put his son through college, he took another night job working for Megastore as a maintenance supervisor overnight. When he began working, he had an initial hazard communication training, but this training was supposed to be supplemented by hands-on training given to him by one of 3 of his coworkers. Unfortunately, none of these coworkers ever trained him. All of them admit that they never had any hands-on training. All of them further admit that despite the fact that they'd each worked for Walmart for more than 20 years each, that they themselves did not know what the hazards were of the chemicals in the solution center, that they didn't know what PPE was necessary, and that they weren't aware of any prior OSHA citation for using the solution center for the dangers of the chemicals. So when Mr. Luevano went to use the solution center on February the 18th of 2017, he operated it in the way he normally did. But unfortunately, what happened was that part of the undiluted chemical came out of the back of the machine. This was a photograph that you'll see was taken by our mechanical engineer who went and inspected the unit, and it actually dripped the undiluted chemical out of the back of the hose. So what Mr. Smith reported was that ultimately this liquid dripping down the hose dripped onto his feet. And he continued working that night without realizing that he had sustained any burns, because what you'll learn from his primary care doctors is that Mr. Luevano is a severe diabetic. He has neuropathy in both of his feet, which leads him not to have feeling in his feet. So as he continued working that night, ultimately what was reported days later were these severe burns as his skin continued to eat at it. It continued to rub up against it, and you see the resulting wounds. You're going to hear from several doctors. You're going to hear from a plastic surgeon, an orthopedic surgeon, and a reconstructive surgeon, all of whom are completely unrelated to any of the parties in this case, except that they were Mr. Smith's treating doctors. Each of these independent physicians, we anticipate that you will hear will testify that Mr. Smith's injuries were not caused by any of his comorbidities. Rather, they all independently concluded that these were chemical burns. In total, there was $171,000 in outstanding medical bills. Mr. Smith has been unable to work as a result of these very severe wounds and daily wound care. We're also going to present to you evidence from these expert witnesses. You're going to hear from an OSHA compliance expert. You're going to hear from a mechanical engineer who's going to explain how exactly this undiluted chemical came into contact with Mr. Smith. You're going to hear from a PhD toxicologist who's going to testify that this chemical can and did, in fact, here cause these wounds. And you're going to hear from a hospitalist and wound care expert who's going to testify that these wounds were most likely caused by his exposure to this chemical and are not the result of any of his comorbidities. And with that, we look forward to presenting our evidence to you, Judge.
Thank you, Ms. Brock. On behalf of defendant, who will be presenting the opening statement?
I will, Your Honor.
All right, thank you, Mr. Jefferson. You may proceed.
Thank you, Your Honor. And the problem with the plaintiff's case is not so much whether or not this chemical could cause an injury, but rather whether it did. And what we will show you through a concise timeline is that it is highly unlikely that this chemical had anything to do with the problems that Mr. Smith encountered on that day, whichever day it might have been, at the Megastore. And so, Your Honor, I would like to share with you a PowerPoint that we prepared.
Yes, and for the record, that's permitted.
Thank you, Your Honor. And so we begin with well before Mr. Smith began working at Megastore. He had a long time history of diabetes. It was uncontrolled at least by March 13th of 2011. He was receiving care for his uncontrolled diabetes. He had a blood sugar level at that time of 425, which is quite high. The accident that's the basis of this lawsuit allegedly occurred on February 18th of 2018. Here we see that in February of 2016, February 29th, Mr. Smith is seeing a physician at that time for sores on his ankles. Again, approximately a year before this accident occurred in 2017. I may have said 18, it was actually 2017, February 18th, 2017. So 1 year before, Mr. Smith is seeing a doctor and complaining about a diabetic ulcer on his left ankle. Now let's move forward to February of 2017. By this time, Mr. Smith has been on the job at Megastore for 6 months or so, 6 months or more, performing his daily routine. On February 1st of 2017, again, accident occurs February 18th. February 1st, Mr. Smith called Sedgwick, the third-party manager for Megastore's benefits, seeking medical leave for medical conditions, and he asked for an extended period of leave through February the 15th. We then see that in February also 2017, that Mr. Smith is reporting to his treating physician and complaining of, again, uncontrolled diabetes. He had stopped taking his diabetic medication, and his blood sugars were at that point over 400 or at 400. On February 9th, he sees his treating physician again. Similar situation, uncontrolled diabetes. He requests a medical leave of absence from February 13th until February 17th. So he doesn't work during that time. He does request and he receives a leave of absence. He attempts to contact his doctor in the days before he returns to work, again, with for complaints presumably related to his diabetes. February 17th, he calls Megastore and it does not call Megastore. He's scheduled to work. He simply does not show up for work on February the 17th. February 11th to February 17th, he's on leave, the leave that he requested for his medical issues. He does not explain what those medical issues are when he requests a leave, but he's granted the leave because of a chronic medical condition. February 18th, this is the day that the incident supposedly occurs. Mr. Smith calls Megastore twice before he goes to work, but he does go to work. And there's no evidence of an incident occurring on that day. There's no report of an incident that day. No injury report is completed. Mr. Smith testifies, as we will see in the evidence, that he in fact went to work that day. He says that's the day the incident happened, but he didn't connect the supposed incident with anything that happened on the job that day. This is the bin that that you've already seen from council. So the week following the accident, do we see anything about a complaint of injury or even an incident report? No. Mr. Smith works the entire week. He worked from February 18th to February 24th. There are no complaints of injury during that time. He receives no medical treatment during that time. On between February 21st and February 24th, he calls asking for additional leave, which appears to be related to the same issues that he's had his chronic problem with. February 24th, he goes to see his doctor and he complains of swelling feet. He's diagnosed with uncontrolled diabetes, a fungal infection, and skin peeling. February 24th, he does not make one mention about any incident on the job contributing to his supposed problems. February 28th, again, he goes back to the doctor, complains about cellulitis, which has been present for 2 weeks, calls it from an unknown origin. In March, the same thing continues. He goes to see Dr. Stipko. Dr. Stipko, he has follow-ups complaining about his ulcers on his legs. They're not improving. Still, no issues about an incident happening at work. March 7th, he requests another leave of absence. No mention about an injury incident at work. It's not until March 15th of 2017 that Mr. Smith finally makes a complaint about something happening on the job at his workplace. So it's almost a full month after the incident occurred that he finally makes a complaint of a work-related injury, and he describes the date of the injury as February 18th of 2017 and begins his workers' compensation claim. So, Your Honor, the timeline simply does not support the plaintiff's claim that whatever happened on February 18th is in any way related to his job at Walmart, at Megastore. And you'll see both through his testimony and through testimony of others that there's simply not a causal connection between his work activities and the problems that he's had basically all of his life related to his chronic diabetes. Thank you, Your Honor.
All right, thank you, sir. I appreciate it. Mr. Espinosa, who's your first witness?
Judge, at this time, we would call the corporate representative for Megastore, Ms. Sonia Rodriguez.
Okay, and you'll be doing the examination, sir?
Yes, Your Honor.
All right. Ms. Rodriguez, you've already been sworn in. The oath is for the duration of the hearing. Mr. Espinosa, you may proceed.
Thank you, Judge. Can you please state your full name for the record, ma'am?
Sonia Rodriguez.
Ms. Rodriguez, I understand that you are here as the corporate representative of Megastore. Is that correct?
That is correct.
And Ms. Rodriguez, you understand that we're here because Mr. Smith alleges that he was injured at work while under your employ?
That's correct.
What is your understanding of his allegation of how this incident happened?
My understanding is that he obtained some chemical burns while on the job, but never reported them. My understanding.
Now, I want to show you some pictures just so we can go and see if we can understand the way that the Solution Center works. I'm going to try to share my screen here. Let me know if you're seeing these pictures, okay? Can you see the photo?
Not yet.
Tell me if you can see the photo.
There I can.
Okay. Will you tell the judge what we're looking at here?
It's the dispensary where our personnel goes to get the chemicals for the cleaning.
Okay, and it's my understanding that, let's see real quick. See if I can draw on here. I'm sorry, I'm trying to draw on it. All right, I'm just gonna mark it. It's my understanding that the worker comes up to this area with a yellow mop bucket to fill it up with water and mix it with chemical. Is that correct?
That's correct.
And so these are the 4 different types of chemicals that they can mix with the water when they approach the solution center?
That's correct.
And Mr. Espinosa, I'm sorry to interrupt, but for the record, this photograph is what exhibit, sir?
Thank you, Judge. This is plaintiff's exhibit number 4, photograph number 1 that we're looking at.
Thank you.
Thank you, Judge. And for the record, I want to show what was marked as plaintiff's exhibit number 5, which is a video. And will you tell us, Ms. Rodriguez, what we're looking at here on this video? Can
You're
you
not
see it?
sharing that. You're not
No.
sharing that.
I'm
I
not
can only
sure.
see the picture.
Give me 1 second.
And Mr. Espinosa, while you're doing that, I just want to state for the record, in case it wasn't already stated, that plaintiffs exhibits 1 through 7 are admitted, as well as plaintiffs exhibit 8. Plaintiffs exhibit 9 is not admitted.
Thank you, Judge. Can I get some help from my co-counsel? Laura, how can I share this video? It's on my screen.
You need to, is it pulled up on your screen?
It is on my screen.
Now when you hit share screen, can you click on that video? The problem was you were already sharing your screen, so you have to get off of share screen and then back on it.
Oh, no, I won't open my Zoom.
Here, I can play it, Javier.
Well, I can't even see you guys now.
More extensive history.
I won't even pull up my Zoom anymore. Let me see. Return to meeting. Okay, there it is. Return to meeting. Okay. All right. Let me try it one more time. Yeah, try it here.
And Mr. Espinosa, and for everyone as part of the edification, all of that is going to be captured on the record unless you mute yourself.
Okay.
So just while we're working through the technical difficulties, feel free to mute or unmute as you see fit for the record.
All right. Thank you, Judge. Let me see if I can do it one more time. I think I've got it.
It's up now, Javier, if you hit play now.
All right. I had to get out of the sharing screen so I could get my video up. Okay. Can you see the video now?
Yes.
All right. Okay, can you describe for us what this man is doing in the video right now?
He's gonna turn the faucet on,
Okay.
and once he does that and click on the button selected above, then the solution comes out in the black
Okay.
hose.
And so essentially what it does is you have a water hose that is connected to the main water supply, and that water hose, this brown hose, goes to the back of the solution center, correct?
Correct.
We see it going out right here. And then that goes through where the chemicals are. And once you push whatever chemical you want, then at that point it mixes with the right amount of water and it comes down the black hose.
That's correct.
And then once it's coming down out with the black hose, that's where it's supposed to go into your mop bucket, correct?
Correct.
All right. All right, I want to show you some of the photos that were provided for us. And I'm going to refer back to Plaintiff's Exhibit number 4. One of the chemicals, and I'm going to be showing you Plaintiff's Exhibit number 4, photo number 3. Can you see that?
Yes.
Okay. What is the name of the chemical on the far left-hand side?
Prominence?
You understand that in this case, Mr. Smith alleges that his body was burned when he was it came into contact with undiluted prominence.
That's my understanding.
Do you have any training that you give to your employees when dealing with a solution center if they're supposed to wear gloves?
If we do, it should be in our employee manual.
Are you aware of any training you give that they're supposed to wear goggles when dealing with a solution center?
Not to my knowledge.
Are you aware of any other personal protective equipment like rubber boots that may be asked of your employees to wear when dealing with this solution center?
Not to my knowledge.
I want to show you these same photos when we went out to look at it, and there was an example that was given to us of how it's used. So I'm referring you to Plaintiff's Exhibit number 4, photo number 5. And here's one of your employees handling the solution center. Do you see that?
Yes.
Do you see her wearing any gloves, even in the demonstrative that took place?
No, she's not wearing any gloves.
I'll show you, see if there's some. Do you see her wearing any kind of rubber boots?
No.
Do you see her wearing even any socks if any of that chemical was to get onto her foot?
No. Not from what I can see.
Let's see if I can see her face. You can't really tell from there, but do you know if she was wearing any goggles when they were demonstrating the use of this machine for us?
I'm not sure. I was not present at the time.
All right. Now, if Mr. Smith alleges that he was not given the proper personal protective equipment to use this machine, do you have any reason to disagree with that?
No.
Were you aware that you were the store manager for this mega store, correct?
Correct.
Were you aware that I'm going to show you Plaintiff's Exhibit number 8? Can you see that?
Yes.
Were you aware that back on August or January 27th of 2012, Megastore was cited for allowing their employees to work with this cleaning dispensing unit without any proper personal protective equipment?
I was not aware.
And so as a store manager, you were never told by the higher ups at Megastore that Walmart actually had a NOSHA violation where they were telling you that on August 17th of 2011, the employer did not ensure that material safety data sheets for materials such as prominence heavy duty floor were available for each work shift. You were unaware of that?
I was unaware.
You were unaware that on or about August 17th of 2011, the employer did not ensure that maintenance employees were required to wear safety goggles or a face shield when dispensing crew restroom floor and surface cleaner a corrosive material. Were you aware of that?
I was not aware.
And for the record, I'm looking at exhibit number 8, plans exhibit number 8. What at the bottom of it, it says page 12 of 15. And for the record, it says the employer did not ensure that maintenance employees were required. You would agree that Mr. Smith was a maintenance person or a maintenance employee for Megastore at the time of his injury, correct?
That's my understanding, yes.
And in the same citation, were you aware that Megastore was supposed to train each employee, to the following? And I'm reading from number 1 down at the bottom, where it's just labeled page 13 of 15 on plaintiff's exhibit number 8. Number 1, methods and observations that may be used to detect the presence or release of a hazardous chemical in the work area. Are you aware of any training that Mr. Smith was given in regards to that?
I'm not aware.
Number 2, the physical and health hazards of the chemicals in the work area. Are you aware of any specific training that Mr. Smith was given in regard to what prominence could or could not do to him?
Not that I'm aware of.
Number 3, the measures employees can take to protect themselves, such as specific procedures, appropriate work practices, emergency procedures, and personal protective equipment to be used. Are you aware of any specific training that Mr. Smith was given in regard to being told, if you're going to be using this chemical, it could come out undiluted, you should wear rubber boots, anything like that?
Not aware.
Are you aware of any training he was given to tell him, hey, whenever you're working with this chemical, you should wear goggles, anything like that?
Not to my knowledge.
How about gloves? Even gloves, are you aware of there's any training that was given that they should wear gloves?
Not to my knowledge.
Your Honor, I object to this whole line of questioning. It's repetitive, it's cumulative, and I think, frankly, we've heard enough.
All right. Well, Judge,
All right,
if I may.
the objections are overruled, but there is a time limitation, so please be mindful of that.
I will, Judge. Thank you, Judge. Now, Ms. Rodriguez, I'm stop sharing, sorry. When Mr. Smith alleged that he was burned with this chemical, can you tell the court whether he had been provided with any type of personal protective equipment when dealing with the Solution Center?
I'm not aware. I'm not sure.
You don't know, you can't tell the court that he was provided with goggles, can you?
I cannot.
You cannot tell the court whether he was provided with gloves, can you?
I cannot.
You cannot tell the court whether he was provided with rubber boots, can you?
That's correct.
And you're not here to testify whether this chemical can or cannot cause burns. You'll leave that up to the doctors, correct?
Yes, I will.
All right. Judge, with that, for brevity's sake and for time's sake, I will pass witness.
All right, thank you, sir. On behalf of defendants, who's handling the cross?
That'll be me, Your Honor.
All right, Ms. Cano, you may proceed.
Ms. Rodriguez, you're not a safety manager or safety, you're not responsible for actual safety components of your employees' work, are you?
No, ma'am.
Okay, there is a designated safety representative or safety officer who is in charge of that?
That's correct.
And so would that person be better equipped to answer questions about safety measures and precautions that were taken with respect to that particular station?
Yes, ma'am.
Would that person also be better equipped to answer questions about personal protective equipment that may have been issued to the plaintiff?
That's correct.
Okay. Now, are you familiar with Mr. Smith's personnel records and his employee file?
From what we have in the file, yes.
Okay, you've looked at it, right? I mean, you're the representative for the company, and you've had an opportunity to look at those records, right?
Yes.
And in looking at those records, did you notice that in the week preceding the date of the alleged incident, Mr. Smith did not actually work a complete work week?
Yes.
Okay.
Correct.
And are you aware that, in fact, during the time preceding, during the immediate time preceding the date of the supposed incident and in the couple of weeks that followed, Mr. Smith had a number of times where he called in either sick or called in and unavailable to work?
Yes,
I'm going to
that's
object to
correct.
leading, Your Honor.
She's answered the question, Your Honor.
I'm still going to object to leading, Judge, and if she can ask the questions of this witness without leading.
Okay, the objections to leading are overruled.
And Ms. Rodriguez, are you aware, well, what date did this, according to Mr. Smith, on what date did this incident supposedly occur?
According to the report that has been presented is February 18th of 2017.
So that's the date that he claims this incident happened, right?
Yes.
Okay. When did he actually report this incident?
Not sure. I would have to refer back to the report.
Okay. Let's look at that report. Let's look at Plaintiff's Exhibit 2, which has already been admitted into evidence, and I'm going to share that document. Can you see that document, the associate incident report?
Yes.
Okay, and so the associate name right there says Mr. Adam Smith, even though you can't see it. But if you look over on the right-hand box, can you see my cursor, what I'm pointing at?
Yes.
Okay.
Yes.
Tell me the date and time of incident.
February 18th of 2017.
Now, the associate, that's the plaintiff himself, right?
Yes.
So this is the date on which Mr. Smith himself reported this incident, correct?
Correct.
Okay, so he's saying in this report that the incident occurred on February 18th, correct?
Correct.
Now let's look at the next line and tell us when he actually reported that the incident occurred.
March 16th of 2017.
Do you have any reason or do you have any understanding as to why it took Mr. Smith approximately 1 month to report this supposed incident?
I don't.
Okay, with that, I'll pass the witness, Your Honor.
Judge,
All right, thank you. Any recross?
Judge, I was just gonna, Ms. Cano, can you just put that exhibit back up? Because I don't think mine is redacted.
Sure,
Fine,
sure.
thank you.
But do you really need a recross? I mean, redirect?
Just one simple item.
Okay.
Just for the, Ms. Rodriguez, on Exhibit 2, Plans Exhibit 2, down at the bottom, do you see where it, I can't do the deal. Down at the bottom, do you see where it reads, do not concur with reported date as indicated by assistant manager?
Yes.
Do you know if Mr. Smith is the one that put that?
Objection calls for speculation.
That objection's overruled.
Do
I
you
am
know?
not sure.
Okay. That's all I have, Judge. Thank you.
Who's
All right.
putting stars on our document?
Not me.
Who is doing that? Is that Judge Diaz?
Is that Tina? That's
Tina.
Tina over there.
Maybe.
She's laughing too much.
It maybe was me.
Well, and so that's a great example. So this came up in the first mock trial. There is not a way that I know of to prevent other people from marking on the screen that you share. So
You know what? There is actually, and I'm looking at it. If I'm sharing a document, I'm going to more, and I'm going to disable participants annotation. Can somebody try to do that again and mark on my document?
Yeah, you just took it off because mine said.
That worked.
Okay, so up on the share screen, like the menu bar I'm sharing right now, I go to new share, pause share, annotate. Over to the right under more, if I scroll down, it will say disable participants to annotate. And so now I'm gonna enable it again, and now it says allow participants to annotate, and so now they can do that.
that is wonderful. Thank you so much, Ms. Cano.
Okay, all right, I saw a heart somewhere, so it worked.
Perfect. All right. So may this witness, are we done with this witness?
Yes, we are.
Yes,
Okay.
we are, Judge.
All right. And again, because the witness is one of the parties, they can stay in the hearing. But who is the next witness, plaintiff's side? Who's calling the next witness and who is that?
Judge, the next witness that we're going to call is the plaintiff, Adam Smith.
All right, Mr. Smith, you've been previously sworn in. That oath lasts throughout the proceeding. Ms. Brock, you may proceed.
Thank you, Judge. Could you please state your name for the record, sir?
Adam Smith.
And Mr. Smith, can you tell the ladies and gentlemen of the jury or the judge here what you were doing for a living back in February of 2017?
I was working for Mega Mart.
And what were you doing for Mega Mart?
I was part of the maintenance crew.
And as part of that maintenance crew, can you explain to the judge what your general job duties and responsibilities included?
Cleaning and maintaining the store.
As part of that work, did you have to use any cleaning chemicals?
Yes.
What training did you receive from Megastore before you were given the job duty of cleaning with those chemicals?
Just a very basic generic training.
Now, did they give you chemicals that you would find on the store shelf, or did they give you industrial strength chemicals?
Industrial.
And what warnings did they give you, if any, about the dangers of coming into contact with those chemicals?
That I can recall, not many, not at all.
I want to show you what's previously been marked and admitted as plaintiff's exhibit number 4. Do you recognize what I've just attached as exhibit number 4, Mr. Smith?
Yes.
What do you recognize it to be?
The chemical station that we utilize to mix our chemicals.
And Mr. Smith, can you, using the annotate feature in Zoom that you can find at the top of your screen, could you draw an arrow for us at the chemical prominence that's included within the Solution Center? Have you just added the blue arrow, Mr. Smith?
Yes.
And is this the chemical that you were using at the time that you believe that you sustained the injury that's made the basis of this lawsuit?
Yes.
Can you explain to the judge what exactly happened on February the 18th of 2017 involving this prominence chemical?
I did what I do every night. I walked over to the station. I turned on the handle, placed my mop bucket here. Once the water was running, I went ahead and pushed this black button, which releases the chemical into the black hose where it mixes with water.
Okay, and for the record, I'm going to talk through this exhibit that you've just marketed. Did you put the X at the bottom of the photograph? Is that inside the basin or outside the basin where you place the bucket?
Outside, I'm sorry.
And then I see you added an additional X up at the top. And can you explain what that button did to your understanding?
To my understanding, that's where it lets you choose a chemical. Obviously, that goes to the prominence, and that's when it releases chemical and it starts mixing with the water.
So as you did that night, did something different happen?
There was dripping on the side of the hose as the hose was inside my mop bucket, which I was holding to fill up my mop bucket.
And where did that liquid fall?
On the side of my foot.
At the time, were you wearing any gloves?
No.
Were you wearing any boots?
No.
Were you wearing any goggles?
No.
Were you wearing a protective face mask?
No.
Did Megastore provide you any PPE, any personal protective equipment to use while you were operating the Solution Center?
No.
Did you know at the time that you were using the prominence what the hazards were, if any, of using the prominence or coming into contact with the undiluted prominence heavy-duty floor cleaner?
No.
What happened next? Did you continue working?
I just continued working my shift.
When did you realize that something was wrong?
In the past, I've had, that illness on my foot due to my diabetes. But it's when I realized that I don't think this is part of my diabetes. It was larger and it looked a lot worse than what it has in the past. And that's when I decided to go to a doctor.
And did you in fact go to a doctor?
Yes.
And I know that we have produced, and part of the record in this case are your medical records. I understand that you've seen many doctors as a result of this ailment. Is that correct?
Yes.
And ultimately, what is your understanding of what you've been diagnosed with by these doctors?
One of the doctors stated that it looked more like a third-degree burn than anything kind of related to a diabetic injury. And so that's when we looked more into it, and that's when we realized that it could have been the prominence from work.
And when did you report that you believe that to Megastore?
I don't remember the exact date, but I know I reported it as soon as the doctor suggested that it could have been a chemical burn.
Judge, before I click off of this exhibit, I would move to admit as plaintiff's exhibit number 11, the annotated photograph that we see, that was the initial photograph of plaintiff's exhibit 4.
Okay, do we have a plaintiff's exhibit 10? Just so we're making sure we've captured all the numbers or not?
I believe that plaintiff's exhibit 9, Judge, was the stipulated settlement agreement that you did not allow into evidence. So if you'd like for this to now be plaintiff's exhibit 9, or if you'd rather keep that plaintiff's exhibit 9 so that the record is clear and make this 10.
No, 10 is what I thought was the next number. I heard you say 11. I'm sorry.
Oh, I apologize. I'd move for this to be plaintiff's exhibit 10.
Any objections?
No objection, Your Honor.
All right. Plaintiff's exhibit 10 is admitted. Now, technically, how are we getting this captured and to the court reporter as plaintiff's exhibit 10?
So Judge, there's a feature here that allows you to now save the annotated version up at the top. So I can save it and then submit it to the court and to the court reporter in the same manner that the other exhibits were submitted.
Any objection?
No objection.
All right, that would be perfect. Thank you. And plaintiff's exhibit 10 is admitted.
Thank you, Judge. Mr. Luevano, when you, or Mr. Smith, when you went to Walmart to make the report, did they ask you to fill out an incident report?
Yes.
And I'm going to show you what was previously entered into evidence as plaintiff's exhibit number 2. Is this the incident report that you submitted?
Yes.
And what day does this show that it was signed, sir?
On the 16th of 2017, March 16, 2017.
And can you tell me whether your handwriting appears here at the bottom right-hand corner of plaintiff's exhibit number 2?
I think so. I can't tell.
Correct me if I'm wrong, but I believe it states, do not concur with reported date as indicated by assistant manager. Is that correct?
Yes.
And why did you take the time to note that on this incident report?
I can't remember.
You do recall, though, that you reported this to them on a date prior to the date that this incident report was made.
Yes.
Okay. Thank you, Mr. Smith. I don't believe I have any additional questions for you. We'll pass the witness.
All right, thank you, Ms. Brock. Who's doing the cross-examination?
I will, Your Honor.
Thank you, Mr. Jefferson. You may proceed.
Thank you, Your Honor. So, Mr. Smith, you just testified that you did not report the incident on March 16th, 2017, correct?
Yes.
You think that it was sometime before March 16th of 2017, correct?
Yes.
But you also know that you didn't report the incident, you did not report the incident on the day that it occurred on February 18th of 2017, correct?
Yes.
Nor did you report the incident on February the 19th, right?
Mm-hmm.
In fact, isn't it true that you didn't report the incident for weeks after the incident supposedly occurred?
Yes.
And in that entire time, you saw doctors, didn't you?
I did.
And when you first saw a doctor because of the problems that you were experiencing, you didn't connect the fact or your belief that what the problems in your ankle and your foot had anything to do with your work at Megastore, correct?
I did not. Yes.
And you're not here to tell Judge Alvarez that you didn't have any problems with your feet before this incident, are you?
Yeah.
In fact, you know that you've had problems because of your diabetes for decades, haven't you?
Yes.
And as a matter of fact, those problems have resulted in ulcers to your feet, correct?
Yes.
You started working at the Megastore about in 2016, isn't that right?
Yes.
So about within a year before the incident occurred, correct?
Yes, sir.
And would you agree with me that your job is basically a routine job? You do the same thing every day?
I would say so.
So every day you would go into the store, and one of the things that you would have to do would be to load these buckets, correct?
Yes.
And you would use that same solution, that prominent solution, to clean the floors of the store, right?
Yes.
And you're a floor cleaning specialist. That's one of the things that you do, correct?
Yes.
And so you would use the same chemical in the months before this incident. You would do the exact same thing. You would go to the store, correct?
Yes.
You would get the bucket, right?
Yes.
You would go to the dispensing unit, correct? You
Yes.
would put the hose in the bucket,
Yes.
and you would push the button. You would turn on the water, and you push the button to dispense the chemical. Isn't that right?
Yes.
And you did that for months before this incident ever occurred, didn't you?
Yes.
And then after the incident occurred on February 18th, you continued your same routine, right?
Yes.
You'd go to the store every day, you'd take the bucket, you'd use the same dispenser, you'd use the same chemical. Routine was exactly the same, isn't that right?
Yes.
And just as a matter of fact, Mr. Smith, isn't it the case that after the incident, and before you first made a complaint that your work was related to your foot problem, that you hired your lawyers?
Yes.
Thank you. I'll pass the witness.
We have no further questions, Judge.
All right. May this witness be excused, but it's a party, so he'll stay in the room. But anything further of this witness?
No, Judge.
Nothing further.
All right. Thank you. Oh, thank you. Anything
Yes, ma'am.
further?
Yes, Judge. The next witness that we would call is one of our retained expert witnesses, David Mansfield, who will appear via his video deposition.
Okay. And is this both the plaintiff's presentation and the defendant's presentation in one cut that's just going to be played continuously?
No, Judge. We're going to play a portion of ours, and then I believe Ms. Cano or Mr. Jefferson are going to play a portion of theirs.
Okay.
That's correct, Your Honor.
Thank you. All right. Ms. Brock, you may proceed.
Where the shoes more of both his feet to the extent to cause that major skin loss that he had.
I want to kind of get to the big one, and this is kind of the big debate now, is whether or not the wounds that
I don't
Tony
think we can see the video, Laura. Can you see
diabetic foot ulcer.
Hold on one second. I'm sorry. I forgot to share my screen. That was like my big main job there, right? Share the screen.
There it is.
All right. Are you going to go back to the beginning, or are you going to just press play? 'Cause, I mean, technically, we just need to capture the audio, but it's up to you as far as how you want to present the witness.
Well, I mean, Judge, if this was an actual trial and I was actually presenting the witness in its entirety or doing something, I would go back. But if it's okay with you, I'm just going to hit play so everyone can get a feel for how a video deposition proceeds.
Yes, ma'am.
Judge, we're in this to win it. I don't know about her, but no, I'm joking. I'm joking.
I'm watching the time. We're getting really close to 5 on a Friday of a.
I'm working with you, Judge. Javier's not.
No, it's okay. All right, let's go forward.
Specifically, and I think you've done this throughout some of your testimony, but I want to be really clear for the arbitrator. What is a diabetic foot ulcer?
Sure. Basically, of course, you need to be a diabetic and you need to have a wound on your foot. That, by definition, I guess, would be a diabetic foot ulcer. They're usually characterized, you usually have to have some kind of injury that happens. You talked about shoes, for example. A shoe rubbing in a discrete area would cause loss of the skin in that area, and then it could get infected and go deeper and cause an ulcer. Well, that basically would be a diabetic foot ulcer. So you might see those in an area, for example, a heel or an ankle where the shoe's more apt to rub, somewhere like that. And sometimes on the sole under the metatarsals, the bones that are like knuckles in the hand that poke down and easily rub in shoes that aren't well padded. And often diabetic ulcers occur on the soles of the foot, also in the heel area on the soles. So, and they're fairly discreet, and they don't cause a huge amount of skin loss. They cause a wound to happen that, if it gets infected, will get deeper and open up and slow. They don't, lose 75% of your skin all at once. They will lose a small area of skin as that gets rubbed off, and then will go deeper if it gets infected. So I don't believe the presentation that Tony had, both on the morning after the exposure and when he saw Dr. Wiersegen, is consistent at all with a simple diabetic foot ulcer. This is consistent with some sort of exposure to cause extensive skin loss to the upper part of his foot and to areas that wouldn't rub on his shoes or other areas at all. I mean, he did have some on the sides, the ankle area on the sides, but he had major skin loss on the upper part of his feet also.
Judge, is that enough for your court reporter?
I believe so. Ms. Gallegos, do you want to try to practice a little bit more with this deposition, or do you want to move forward?
I hear him perfectly. We can move forward.
All right, thank you. All right, Ms. Brock, do you pass?
Yes.
Thank you.
Your Honor, I do have my offering as well. Can I present that?
Yes, ma'am.
Okay.
Ms. Cano, you may proceed.
Thank you, Judge.
By, let me get the right person. Data sheet. Those two sources of information. All right. I did. And did Dr. Wiersgen's record suggest that he believed that Mr. Luevano's wounds were atypical? Yes.
Thank you, Judge. That concludes our offering.
All right, thank you, Ms. Cano. Any other witnesses?
No, Judge, with that, the plaintiff rests.
Okay. On behalf of the defense, any other witnesses?
No, Your Honor. Defense rests.
All right, thank you. On the closing, is there a time limit that was agreed to by each of you, or is it going to be open?
Judge, I believe our time limit is 2.5 minutes.
I think it was 30 seconds.
Like 20 minutes, Judge.
All right. We'll have it proceed open, but the time is now 4:26. On behalf of plaintiff, who's doing the closing?
Judge, you'll be pleased to hear that I'm going to give the closing.
Thank you, Ms. Brock. You may proceed.
Judge, I believe you heard over the course of this trial from many independent witnesses that Mr. Smith sustained third-degree chemical burns on both of his feet in places that appeared that were not consistent with an ordinary diabetic ulcer caused by pressure on his feet. You've heard evidence that Megastores knew that the chemicals that Mr. Smith was coming into contact with could cause wounds such as these, and you've heard that they failed to provide any of the training or personal protective equipment that OSHA told them that they needed to provide to employees at this specific store. And for those reasons, we'd ask that you make a finding of negligence against Megastore, which is a non-subscriber to the workers' comp system in the state. We believe we've shown by a preponderance of the evidence that they were at least 1% negligent in causing these injuries, and we'd ask for full damages to be awarded on behalf of Mr. Smith. Thank you.
Thank you, Ms. Brock. On behalf of defendant, who's moving forward with the closing?
I will, Your Honor.
Thank you, Mr. Jefferson. You may proceed.
Just very briefly, Your Honor, this is a case about common sense. And when a person sustains a burn injury such that when they go home, they're scraping the skin off of their feet, they know it. And if there's a cause for such an incident, it's not a mystery to the person how it happened. Mr. Smith has had years worth of problems with his feet. He had months where he worked at Megastore with no incident using these same chemicals. After the incident happened, he simply did not report the incident for nearly a month or connect it to anything, his foot problems, to anything related to his work exposure or anything having to do with his work. He would know best. When he sees a doctor, he wants to tell the doctor everything the doctor needs to know in order to treat him properly. And he never mentioned anything about an exposure. And the only time that he discovered that he might have had such an exposure is after he received legal consultation. That is no disparagement against the lawyers, but once one knows what it takes for them to have a recovery in a lawsuit, it is not a surprise that they then create the story necessary to achieve that result. And that's simply what happened here. And so, Your Honor, we believe that there is not sufficient evidence of causation between whatever happened at Megastore and what happened to Mr. Smith's feet. And we would ask for because of that, a finding of no liability for Megastore.
All right, thank you, sir. So I am going to borrow from Judge Alvarado, and I'm going to go ahead and take this under advisement. I'm going to review the exhibits. I'm going to circulate my rulings by judge's notes and ask that the attorneys, upon receiving the judge's notes, the prevailing party will submit the proposed judgment. If it cannot be agreed to as to form, then we'll have the motion to enter via Zoom, at a later date. So with that, we're going to conclude the hearing. But I do want to open it up. I see that there was an exchange on the chat regarding the ability to save an annotated exhibit. And I also want to open up the floor if there are other questions or other comments that we can exchange the ideas and best practices, at least for a few minutes before we leave the meeting, or leave the hearing rather.
Your Honor, the one thing that I will add is that that area where playing a video clip, there's a certain setting that you have to have, and I'm not sure why others don't seem to have that problem, but for me, I can't play the audio clip automatically and have everybody hear it. If I'm playing it, people can't hear it, and so I really do have to make sure that the speaker it's clicked on the setting that says same as system, and then once I actually display the video clip, then I have to go to an option under that more menu and select optimize for video playback or something like that. But you have to optimize it in order for you to hear it, because every other time that I try to play it, you all could not hear it, and I have to do that every single time.
So you did the enhancement and then you press play, or you've got to press play and then automatically or quickly do the enhancement on the view options?
I have it on pause. I'm already sharing it, but I've paused it, and then I go and click on that option before I play it, because if I played it before I do that, you all cannot hear anything.
And that did happen when we practiced before. Has anybody else encountered that? Has anybody tried to share video depositions or audio on a share screen function?
I didn't know that was a problem, Judge. When we played it, it automatically played and there was audio. The only thing I had to do was turn up my speaker volume, then turned up the volume of the video itself. So that was unusual that each of us ran into different issues when trying to play the video for the first time. But that was my only issue with playing the video. I haven't ever had that issue come up.
I have a question, Laura, in looking at your PowerPoint and in mine too. we're actually seeing what the presenter is supposed to be seeing as opposed to what the audience is supposed to be seeing. Because
Yeah, I noticed that when you played yours. I think it's just, it'll show exactly what's on your screen. So the fact that that's what was on my screen, I needed to change the presenter view on the PowerPoint presentation to just the simple view and not presenter. That would have been the fix.
Yeah, I was gonna make that comment. I think that everybody, that whatever you're seeing on your screen, that's what we're all seeing. But I think if you just go to slideshow from beginning and just play it as a slideshow, then that'll fix that.
The question that I had for you, Laura, is did you have your, is your laptop on an extended desktop?
Yeah, I'm on my computer at the office, so I had two screens. So that's why it was showing on the front screen, the presenter view, and then on my side screen, it was showing the actual view, and I needed to flip that.
So that was my problem yesterday also, Judge, when we were running through this day before yesterday, is if you have multiple screens up, it makes it complicated. And so if you're gonna, it's simpler if you're on one, number one, if you're on one screen, and then secondly, if on that screen you make sure it's not on extended desktop on your display.
Mark Unger, you had a question in the chat.
I was going to, and sorry, I'm juggling two webinars here.
Oh, it's okay.
I presume that when you're showing the PowerPoint on shared screen, for those folks that have tried it, that any notes would also show up. So if you have speaker notes, they would also, if you're going from the presenter view, show up. So obviously that would be bad. And then I think there's another function that for anybody that has iPads and you're set up on your primary desktop or laptop, what have you. And I agree with Lamont on running it from one screen as opposed to multiples, but you can share, you can queue up your evidence, for example, on your iPad next to you. And then under share screen, you can share to your iPad. So it's already set up for you and you're not having to negotiate everything just on one screen, for example.
And where is that? So when you share your screen, it gives you an option if you have your iPad tied to your computer via Wi-Fi, or how do you get that option to share screen or share your iPad?
If you click the share screen button in the bottom center of your screen, you're going to see multiple options to what to click. The first one that's default highlight is desktop 1, for example, on mine. But if I look over, I can see that I have set it up to where I can share my iPad, and as long as I'm on the same Wi-Fi network, I can then click that, and then I tap the iPad screen, and then I scroll down from the top right on the most current ones and hit screen mirroring. What you're doing on the iPad is in the same way that you would be doing it to your Apple TV on TV for anybody that has an Apple TV. You're sharing your iPad with the screen share on your primary computer that's in Zoom. So if that makes sense. So it's two functions. One, share screen, choose iPad. Two, on your iPad, swipe down from the upper right corner on the most recent version, and then hit screen mirroring, and it's like turning it on. So for those that have ever used TrialPad, for example, you have a war room mode, and it's basically like, hey, you're queuing something up, but you're not publishing it yet. And so you hit that screen mirroring, and it's like publishing it to your primary Zoom screen. So it's an added benefit after a little bit, because you're talking about those two screens, perhaps Lamont, without the problems of multiple monitors, dual monitors.
I think the only problem with that is remembering that you can still see yourself. So if I had it on my second screen and I was showing someone something mirroring on my second screen, then I'm not looking at the camera, which then alters the display. So it's just, and it's just
nature of the beast, I think.
Same with annotation. So you just, whatever works best, but there's options.
Okay, and we've got a question in the chat. Krista Branch, your question is, during an actual hearing, if you lost the connection and had to be readmitted, the host, which presumably would be the judge, would know because I'm the one that's got to grant you permission to come back in. So I've set up all of my hearings to have permission before you enter into the hearing. So it would be noticed, but that's good because then we'd be able to track on the record what was missed or what happened. Judge Alvarado, you had your hand up?
Yes, and it's going to, what I saw in the feed earlier regarding other people being able to download exhibits and documents that are shared to the feed. It raises one bit of concern for me on that is if you have folks that are just in the room as spectators, they also have access to those documents to download them to their computers. And I don't know if there's anything to indicate on anybody's end that somebody's done that, because I was able to do that with one of your exhibits that you had uploaded. I just wanted to see if I could do it, and I did it. And so it kind of gave me some pause as to all the people that are in the room and who's going to have access to those documents. I realize they're being published in open court, but it's one thing to publish them in court and have somebody sit in the gallery and see them. It's another thing if somebody just downloads them onto their computer. So there, that maybe what we should do is that would be where maybe the private function would be allowable, is you can allow for opposing counsel to review a document that you're presenting to the witness for review, and then present it to the judge in a private chat. Granted, that's a lot of extra steps, but I just don't know how to circumvent somebody just downloading a document or downloading every single item that's put in the chat that maybe shouldn't have access to.
Judge, it was my understanding that it wouldn't be that anyone could have access to the Zoom, but that maybe Zoom was then going to be broadcast on either the Courtroom View Network or YouTube or somewhere else.
And I think that
would
one way.
Well, and see that there's so many different avenues of what we're trying to juggle with. So for instance, if we broadcast live stream it on YouTube, there's a lot of concerns about information getting out there. For instance, if you saw in my hearing, there was some concerns about social security numbers. There was concerns about, typically, you ask a witness, can you state your address for the record? Some people don't want to do that if they know it's going to be live streamed. So one of the ways that, and I've seen it set up, for instance, like Judge Diaz and Judge Jimenez have their YouTube stations set up right now. And you can see in the comments section that they actually have the Zoom link with the meeting code. So if somebody's interested in going to their YouTube site, you might not have to see it live stream, but if you go to the comments, you can click the link on and use the meeting code to access it. I think, me personally, if I'm going to use my YouTube as the public forum for where people go to, if they want to see what's going on in my court, I might just put the telephone access number there instead. So if somebody's interested in participating as a spectator, they can just dial in a phone call and then they can hear it by way of phone. That way it doesn't give them full access to all the features of Zoom. Because also, if you noticed, for instance, we had Judge Diaz photobomb or Zoom bomb me by accident in the last hearing, and she's a spectator.
And she did it on purpose, this one.
So just some consideration when you're sharing in that chat. Just be aware that pretty much anybody who has access to the Zoom platform can download that information.
Yeah, and I think I'm gonna try to use the YouTube only to publish the link for the Zoom meeting, because I think I want to know who's in the hearing, to be honest. I think that's given the status of where we're at and kind of the sensitive nature of the majority of our cases, if not all of them, on one level or another. I think not just the court, but I would imagine the attorneys and the litigants want to know who's in the hearing. And I think just feeding it to YouTube, we lose that. I don't know. Again, that's not knowing how to balance whether or not there's anything nefarious that can be done by participants once they're in the Zoom and how disruptive that'll be before they're kicked out or put into a waiting room or things like that.
Well, if I can, one of the things that I'm anticipating with the phone conference, because when somebody comes in on a phone call, the little square that you're in has a phone that's like a little white phone design on it. So you know that person is in on a phone call. One of the things I was thinking about doing was having that person identify themselves for the record. And that way we know who's coming in on the phone call, because it's the same thing as if somebody's coming in that's a participant, you know, that's sitting somewhere in the Bahamas watching the hearing. They can come in, for instance, there's a Jessica B in the room. Well, I don't know who Jessica B is, and she's got her screen blacked out. And so they could come in just like that in Zoom, and they still can try to sabotage. I think everybody's going to have to kind of find their own comfort zone. But I think if you go live streaming, you've got concerns. If you provide the link and access to the meeting, you have concerns. And then if you have the telephone, then you have some concerns too. I think with respect to controlling information and who's receiving information, they all have their pitfalls. So we have a lot to consider, a lot of details in conducting these.
Yep. Is there anything else? I don't know if we came up with an answer regarding how to protect exhibits that are shared on the chat. I think something else that's being considered or that was discussed is whether or not to just shut off the chat function entirely and just have the exhibits exchanged before the trial. And to the extent anything happens during the trial, they would be circulated. They would be admitted on the record, but circulated and provided to the court reporter and the court after the hearing. I don't know if anybody has thoughts on that.
But we just email the exhibits as, like, for example, if Laura hadn't done that one on the chat, she could just have emailed it to Lamont and Emma and the court, the clerk, and everybody there when she gets it from the computer. Since we're all kind of on a computer, we can check our email. That would be one way to do it if we disable the chat. Because the other thing that I was thinking, you know, anybody can come into these and you know, you can change your name on there. So especially if it's just a deal, how do you know who it is? I could say I'm somebody else, and you know, so that would be, I think the more limitations you put on people observing, the better.
Mary Berry, you have your hand up?
Yes, I had my hand up, and I think what Javier was saying about putting those exhibits, not putting them through Dropbox instead of the chat. I know on the first mock we were talking about putting them in the chat with the hyperlinks and everything, but I think because of what y'all just said about the security and anybody being able to download anything from the chat, I think it's a great way of just doing away with the chat and using everything through Dropbox, or like Javier said, email all the exhibits. But as y'all know, when we have a lot of exhibits, you cannot email them. They have to come through something like Google Drive or Dropbox. There is a share function there where what you could do as attorneys is, we have to do this for the Fourth Court of Appeals, and we have to create the bookmarks. So if you have a bookmark, and Mark Unger was saying earlier, you know, like a smart link, the bookmark creates that hyperlink that you need. For example, you can have all of your Dropbox folder, send it to the court reporter. They're all bookmarked, and they would be like, say you have plaintiff's exhibits 1 through 20. Then whenever you do have whenever you do go to any specific exhibit, you just hit that exhibit number and you can share it and pop it up on a screen. That's something to think about, instead of earlier that we were discussing, you know, let's just put them on the chat. But it's dangerous when anyone can download a document from a chat. And I think when you do Dropbox, you have to literally say who is going to share that. So you can actually just have counsel, the court reporter, the judge, and that's all you allow to share. So the public can never get into those exhibits that are in your Dropbox.
Thank you.
One point I'd like to make, and this is from the webinar earlier today with Judge Villarreal. He was talking about he's not a fan of having the exhibits emailed to the judge because what he's envisioning is going to happen is he's going to have a mini backlog of emails with all these exhibits related to various cases potentially, and then he's going to have a lot of micromanaging to do within his email. So he's trying to stay away from that and stick with the share drive as the option.
I wanted to chime in too. I noticed that when y'all were putting up the exhibits that they weren't dated. And I think that might be pretty important as to we're going to be hearing a lot of stuff and they might be getting misplaced or something like that. So if you put respondents, whatever, can you also please include the date that I guess judge that was offered?
Yes, and you did say that, Maria, earlier. We just didn't know what date we were going. So I know when we marked it and practiced, like downloaded those exhibit stickers that we could edit. So I apologize. You did ask us for that.
I did want to ask one more thing. I'm not sure if when the video was being played, you know, during a trial, we are used to the words coming in on the bottom. And I'm not sure if that's just during trials or if that's also during these hearings, if that's going to be something that's going to be done, or we just rely on the deposition transcripts that we're receiving through Dropbox or through email.
I think that's going to depend on the trial and the attorneys, just like when we're live, right? Some people play it with the script on the bottom. Some people play it just with the visual.
One of the reasons why I was really asking that is because sometimes these names are difficult to spell, and if you see them, you know, it just makes it easier that we won't forget to ask the attorneys how to spell this or whatever, if we can't find it on the internet already.
Anything else that we should talk about, or any other questions that came up? I know sometimes it feels like there's more questions than answers, but I guess one thing I want to say is I want to thank our litigants, Javier, Lamont, Laura, Emma. Thank you so much for your preparation. I know a lot of work off screen and even with me on screen went into this, and again, thank you for working with us to make sure that we could record this so other members of our bar could watch and get some tips from your trial strategies via Zoom. But was there anything else that we should talk, or we could talk about now? Anything that was inspired by what y'all saw over the last hour plus?
I mean, the only last thing, I don't know if there's a solution to this, and Mark, you can chime in here, but it's a little disorienting that we have to have all of these blocks visible. I mean, is there a way to either minimize them, or, you know, just have the participants? I appreciate and I agree with you, Judge Alvarez, that I want to know who's in the hearing, but at the same time, as we're in examinations or presenting documents and things, it gets a little confusing when you got 30 boxes on your screen.
Speaker view, and in the upper right corner, if you click on speaker view, it'll change to show just the person speaking in the big part of your screen. And then if you start talking, go ahead. Okay. And it should switch to you in that way. And that's different from gallery view, which is going to show everybody, aka Hollywood Squares. When the screen share is on, that grid view should shift over to the right side of the screen, I think, vertically. So grid view versus speaker view may make it better for you.
Thank you. Anyone else? And Mark, I saw that you put something in the chat about indexing, the smart index.
Yeah, so I like to create smart indexes of all the pleadings to where I have, pleading number 1, plaintiff's original petition, and then I'll have number 2, respondent's answer. And if I highlight that in Word and hit Command K on a Mac or Control K on a Windows machine, I can then right click and paste in that highlighted portion of text a link. That link would be to where I keep that pleading in Dropbox, for example. So you go to wherever you're storing it and find get the link, which is usually in Dropbox, it's a right click function. I don't have anything queued up, and I have some stuff on my computer like that from cases, so I don't want to necessarily share a screen right now, but I can try and put something together. But basically, you're getting a link of where you're storing your document or pleading in the cloud, and you're embedding it into the title of that in your Word document. And then preferably, if you're going to share that smart index, you want to convert it to a PDF first so that you're not sharing, say, the Word document. Everybody gets a PDF with hyperlinks to all the pleadings, especially the judge, who can just pull it up. And if they have dual screens or dual monitors or whatnot, they can say, oh yeah, I see your pleadings right here. And the attorney could say, for example, it's pleading number 32. Scroll down 32, it's going to be blue like a hyperlink on the internet. And you click on it and it should take you and open up that pleading that the attorney is referring to. If that makes sense.
It does, although, yes, Judge Alvarado asked if you could type up a set of instructions.
I'm not ordering it. I'm just asking.
Just asking.
I've heard those asks before.
Well, and we know you've been doing this tech stuff for what, at least 10 years or so. So you probably saw this coming before anyone else did.
I been accused of liking it better than practicing law by many. So.
Well, if you can, we'll share it if you don't mind. But I know
I'll do a smart index cheat sheet
tutorial kind of thing. Yes.
Sure.
Anything else that y'all can think of, or anything else that you'd like to ask? And again, with the recognition that right now there's probably more questions than answers.
I think that workflow mentioned, I don't know if it was by Laura or who was mentioning the playing of audio and video files and the need to have that setting, to change that setting before it plays. It seems to be happening for some people, but not others. It happened to me before. And so if there's a workflow, a quick and easy cheat sheet that can be created for that, that will save everybody a lot of time in hearings when attorneys are trying to pull up audio and video stuff. That would be significant, I think.
Yeah, that was Emma.
Emma
who had to do that. Yes.
Yeah.
Yeah, and that, again, it took me a long time to figure it out, but I messed with it and eventually found that function. And I've got to do it every single time.
Yeah. Are you on Mac or Windows?
Windows.
Okay.
And I don't know if it's because I have multiple screens, multiple audio sources, or I'm not sure what it is.
I had the same problem, and I think I accidentally figured it out, and then I blocked it out. I don't remember the solution anymore. So
I'm happy to share it because it's
yeah. If you could type it out or just, I don't know.
Absolutely.
Workflow it. Thank you.
Your audio did sound better today.
I know.
She worked on it.
I sure did. I'm proud of it too.
All right.
For those that are interested, Judge Miskell out of Dallas and Judge Ferguson out of West Texas are currently broadcasting a YouTube webinar with Crystal Thompson, and that should be saved and be able to be played back on their YouTube channels. And I think the 470th is Judge Miskell's, and I can't remember what Judge Ferguson's is, but if anybody wants it, email me and I'll send links. They're on it right now. They're doing it.
Yes, and I think for those of you who are not familiar, the Family Law Bar Association of San Antonio on their Facebook page posted those 2 links. And I'm really, really grateful and really happy to be part of this legal community, because there's been a lot of information sharing and a lot of collaboration, and I'm sure that's going to continue in the weeks and maybe months that follow. But if you're not part of these Facebook pages, and crossover, right? PI come to family and vice versa. But I'm really proud to be part of this community with all the information sharing and the collaboration. So I thank all of you for that.
And the attorneys, I know, are like crazy grateful to the judges who are working so hard on it, because this is not easy stuff. It's just not easy. So thank you.
Thank you. All right, y'all. Well, it's Friday. Judge Canales, I'm sorry, did I cut you off? Did you want to come in or say something?
No, that's fine. No, that's fine.
I know it's hard to keep track, but it is Friday in our virtual work week or remote work week or in the office work week. It's Friday. Thank you all so much, and enjoy the weekend, what you can get of it. And Judge Alvarado, thank you so much for putting this together. Judge Diaz, Judge Canales, thank you for joining us. And thanks to Judge Salinas, who was here, but I think she had to leave to go to something else. So what do you say? We're recording.
No, thanks.
We're recording.
Yikes. Thanks to everyone for their participation.
And to our litigants, again, thank you all so much for all your work. All right. Thank y'all. Have a great weekend.
Thank you, Judge. You too. Bye-bye.
Bye-bye.